I call to order the meeting of the Bills Committee on Statute Law Miscellaneous Provisions Bill 2025. Let's welcome the government representatives to join us. I'd like to let members know that this meeting will last for 3 hours and 45 minutes, depending on the progress of our discussion. There'll be a 10-minute break around halfway through the meeting. Let me first invite the administration to enter the meeting room. While we wait for the government representatives to join us, I'd like to let members know about this. The deadline for accepting public submissions on the bill was the 28th of May. The Secretariat received 3 submissions, and the first batch of administration's response has been uploaded to the LegCo website. Welcome, government representatives. Follow up to issues arising from the previous meeting. Please refer to LC paper number CB bracket 21062/2025 bracket 01. The administration has already provided its response to the issues raised at the last meeting. Please refer to LC paper CB bracket 21062/2025 bracket 02. Now I'll invite Mr. Wesley Wong, Secretary of the Law Reform Commission, to walk us through the response. Thank you. Thank you, Madam Chair. As mentioned by Madam Chair, there were issues raised in the previous meeting, and we have already provided a written response. Perhaps I'll invite colleagues from the Development Bureau to walk us through the response. Development Bureau, please. Before you speak, please let us know your name, please. Please speak louder. This mic has not been switched on. Thank you. I am Mr. Stephen Low from the Development Bureau. I'm the Principal Assistant Secretary. We've prepared a written response to the issues raised at the last meeting. I'll first talk about the issues concerning the Crown Lease Pak Fu Lam Ordinance. The previous meeting, members asked why we are repealing sections 3 to 10 while retaining Cap 118. The Crown Lease Pak Fu Lam Ordinance back in the 1960s have, in accordance with the laws at that time, have a mechanism for preparing for plan. There's no way for people to make relevant applications in accordance with sections 3 to 10. Members of the public, where necessary, may visit the Hong Kong e-legislation website for past versions of Cap 118. We have considered an alternative, that is to retain sections 3 to 10, but then we'll have to keep terms with colonial connotation, namely governor, and the Chinese rendition of district court and judge, and will have to make relevant adaptations. We don't think this is an appropriate approach. This is because we will have to look for an alternative for the term judge. However, the Supreme Court had been reconstituted in 1976, and on the 1st of July 1997, it's become the High Court of the Hong Kong SAR. Therefore, any attempt to replace the Chinese rendition of the term judge will involve a rewriting of sections 3 to 10. As mentioned, the above provisions have already lost their effect. So if we are to look for alternatives to replace the colonial terms, it might not be appropriate. Therefore, we made the proposal to repeal sections 3 to 10 and make adaptations to the other sections. On the paper, do you have to give further elaboration on the responses? If not, members who'd like to speak, please press the request to speak button. I'll give 4 minutes to each member, including questions and answers. Now, we talked about LC paper bracket 01 and paper bracket 02. Mr. Stephen Low, PAS, you have just given a reply to certain parts of the issues. For the rest of the paper, will you continue to walk us through the response? Yes, Madam Chair. On part 2 of the question concerning the Crown Lease Park Full Lam Ordinance, it is about whether the aforesaid criteria also apply when considering whether to repeal provisions in other existing ordinances. As a matter of general principles, we have to consider provisions that contravene the constitutional framework of the SAR. We'll have to also consider the relevant policy intent of the provisions. It might be necessary to replace or rewrite some of the provisions instead of simply having alternatives to replace certain terms. So we've talked to the DOJ for each provision. After consulting the DOJ, we will look at them on a case-by-case basis to decide whether we need to propose any amendments. Now, to make this meeting more effective, each member, before we came to the meeting, we have already read the paper, so you will not have to read out the response word by word. Please be brief. I'll invite my colleague to walk members through the other issue. I am from the Development Bureau. I am Ms. Fabia Tam. At the previous meeting, we talked about the Foreshore and Seabed Reclamations Ordinance. And members asked whether the actual commencement date of the ordinance could substitute the editorial notes. We've talked to the DOJ about this. We think that the current provisions are easily comprehensible. If we are to amend the commencement date, we will have to amend section 20 bracket 1 and section 20 bracket 3, but there is no need for us to amend these two sections. So taking the above into consideration, we think it is appropriate to keep the current proposal. Now, on the issue about pleadings, at the previous meeting, members asked why we use pleading instead of pleadings, that is in the singular form. Under the partition rules, the term pleading, well, we made reference to the meaning given by the rules of the High Court, and the pleading in singular form is used in the rules of the High Court. Next issue concerns the block crown lease. At the previous meeting, members asked why we make amendments to the various references to block crown lease. After amendment to the long title as well as the section 2, the interpretation of block crown lease will be kept. As to whether the term block crown lease should be kept at cap 488, well, as mentioned, the term will be retained in the relevant sections. Also, it will not terminate the BCL 1905 arrangement. Also, it has reference with the leases granted after 1997, so we think that it is appropriate to keep the term block crown lease. Now, about the interpretation and general clauses ordinance. Currently, the interpretation for crown lease has been kept for any instruments granted before the 1st of July 1997 under the Interpretation and General Clauses Ordinance. We gave full consideration when we decided to keep the interpretation of crown lease. Also, under Cap 1, the interpretation of government lease is also included. Have you finished this paper? Well, there is another question raised by members about why we do not keep the word block. According to Cap 488, we think that the subleases are now considered as government leases. So we think that it is appropriate to have the abbreviation. Some members asked whether the amendment will have any impact on the legal sector or the public. We did a research. The term block crown lease only exists in Cap 488 and the Lands Tribunal Ordinance, Cap 17. We want to make the relevant amendments through this bill. And the relevant amendments only concern leases in Cheung Chau. We think that there won't be any significant impacts on the legal sector or the real estate sector. If necessary, members may visit the Hong Kong e-legislation website for past versions of Cap 488. So the administration has given a response to the issues raised at the previous meeting. Members who would like to follow up, please press the request to speak button. I'll give each member 4 minutes, including questions and answers. If further follow-ups are required, I might ask the administration or the legal advisor to provide written responses. If members have no questions in this round, I will carry on with the meeting. On the 9th of May 2025, the legal advisor wrote to the administration, please refer to CB bracket 2878/2025 bracket 01. The administration has already provided a response to the letter. That's LC paper CB bracket 21146/2025 bracket 01. I suggest that the administration walk members through the response during the scrutiny of the relevant clauses of the bill. The Bills Committee received a letter from Professor Priscilla Leung on proposed amendments to clauses 8 and 9 under Part 5 of the bill. Professor Leung's letter was circulated to members on the 30th of May. The Secretariat has asked the administration to provide a response to the letter. I suggest that we have Professor Leung brief us on her proposed amendments when we come to Part 5 of the bill. I'll also ask the administration to respond when we come to Part 5. Do members have any objection? If not, let's carry on with the clause-by-clause examination. Now we've come to the clause-by-clause scrutiny of the bill. Members have agreed that we look at the reference table issued by the Secretariat on the 13th of May. We will also look at the marked-up copy prepared by the Legal Service Division. That's LC paper CB bracket 2842/2025 bracket 01. Like last time, we will mostly use the marked up copies. We will look at both the Chinese and English versions of the marked up copy. Please also refer to the reference table to see which part we are at. We will not look at the clauses according to the order of the bill. Government representatives will take turns to brief us on the policy issues under their portfolio, and they will also walk us through the relevant clauses. Now, I'll invite Mr. Wesley Wong, SC, the Secretary of the LRC, or Senior Counsel, Mr. Lee, to walk us through the bill. Before you walk us through the relevant clauses, please let us know which government department or bureau you represent. Also, please indicate the page numbers of the Chinese and English copy so that members can easily find the page numbers. Also, when you explain the clauses, please read out the Chinese version first and then the English version. Thank you.
Before the end of the last meeting, the committee has already gone through the clauses proposed by the Development Bureau. Now we will continue with the Part 21 of the Blue Bill. Would members please draw reference from the reference table, page 2, and also our markup copy. Chinese version is page 117, English version is page 116. When we're going through clause-by-clause examination, if members have any questions, please raise them after the government representatives have given their explanation or the introduction. Please press the speak button, and the government representatives as well as our legal advisor will respond, and also draw members' attention to any legal points. First, let's invite Mr. Wesley Wong. Senior Counsel, please. Thank you, Madam Chair. Part 21 is about Cap 159 of the regulation with respect to the amendment to intellectual property. So we would like to invite Mr. Lau from the IP department to walk us through. Thank you. Part 21, Clause 70 is to repeal 159 bracket 1CA. Regarding this proposal, it's in relation to Part 69, repealing the term. So I suggest that we make reference to the second part first, so that we have a better understanding of the present amendment. Can you please walk us through, or let us know which page would that be? Chinese version on the markup copy is page 418. English version is 433. English version is 433, page 433. Regarding Cap 159, sub-legislation 1, on solicitors, trademarks and patents cost rules. This is to propose to repeal 159 sub-legislation I. When this part of the legislation was enacted, it was regarding Cap 149 and 143 about trademarks and patents which are non-controversial. For instance, about submitting the applications for trademarks and patents. So there is a standardized fee table. But for Section 43 and 49, the respective parts have been repealed and replaced by 154 and 599, replaced by these two. So for 159I, this has been invalid. So it's also not applicable to the present trademarks and patents regulations. For handling disputes regarding trademarks and patents, the lawyers will, according to Cap 159, will discuss with the clients and also discuss about the fee levels. And with the consent of the judges, so this would be this kind of a discussion would be carried out. That's why, in other words, Cap 159 sub-legislation I is no longer applicable. All right, so on the markup copy, English version, page 4. Chinese version 418. So in the table, it's page 2. That is part 69. Repeal of certain enactments. Professor Priscilla Lam. Madam Chair. Well, these two regulations had been repealed by 97 and 2001. What I'm concerned about is about the process, because in the first part, when we were discussing about the amendments, we already mentioned that there should be some amendments to relevant parts of the regulations. For instance, there are some terms that are outdated and not suitable. So these two regulations had actually been repealed, respectively, in 1997 and 2001. How come we are only doing it now in 2025? I want to know what's wrong. Why do we have to do it now? Because these two parts had already been repealed in 1997 and 2001. All right? That means, is there any problem about the process? Why is it that it has to be brought up now in 2025? Yes, Madam Chair. Recently, we have done two review exercises in 2016 and also in 2020 regarding trademarks and the Madrid agreement, the relevant parts which are applicable to Hong Kong. So we had already done some review regarding trademarks and patents. We have also made some miscellaneous amendments. However, during that exercise, we were looking at the outdated terms, especially those terms that are no longer applicable to the Hong Kong SAR. And so we've made some simple and straightforward adaptations of the ordinance. But now, as we're doing miscellaneous amendments, we think that we should also look into the entire legislation and see whether there are other parts that have to be amended. And that is why we hope to make use of this round of exercise to repeal those outdated terms. Professor Leung, Madam Chair, I think he hasn't answered my question. Well, last year we've already pointed out that in Hong Kong there are a lot of regulations and legislations that are outdated. So first of all, there is a problem in the process. It seems that it just dawned on you that you have to do something that haven't been done in the previous review exercises. How come these kind of amendments had not been done in the 1997 and 2001 review exercises? This is the first point. There is some problem in the process, in the review process. Well, of course, I think there is a lot of time lag in the amendment process. Well, can you make use of some technology to do better cross-referencing of the various legislations? Well, when I was doing the law adaptation exercises, we made use of some technology to do cross-referencing of the various legislations. So I'm really very concerned about the process. Now, perhaps after this year, next year, you might come up with another batch of outdated legislations. Can you just do it in one go to do cross-referencing at the same time while you are doing the revision and proposed amendments? Thank you, Professor Leung, for your suggestion. We really hope to make use of this opportunity to comb through all the outdated legislations and see whether there are terms that should be repealed or replaced. Thank you. Follow-up, Professor Leung? Yes, my follow-up question is not just about the Department of Intellectual Property, but perhaps the DOJ or the relevant bureau doing this review exercise should be aware of this problem. It is not difficult at all. There is a search system. You just make use of technology to do the cross-referencing in one go. Don't do it by batches. Is it because we are lagging behind in our AI technology, or in the drafting division perhaps they don't have this technology or know-how? Well, Professor Leung's question is not just about Part 68. I think Professor Leung is talking about the entire process. There might be problem in the entire review process, and she was saying that perhaps you could make use of technology to do better cross-referencing while you're doing this review exercise. Well, this is very clear already, and perhaps Mr. Lau can respond again and see. And later on, the senior counsel and Mr. Wang to see whether you have any supplement. Mr. Lau first. Thank you, Madam Chair. Yes, exactly. We're making use of this exercise to go through the legislation to see whether there are any outdated parts, and that is why we are now proposing amendments and also repeal. We are going through not just one legislation, but also we are keeping in view of whether other legislations will be outdated. This is what we have been doing, and we will continue to do so. Thank you. PAS. Yes, we understand Professor Leung's concern. And during the review of the statute law, we are exactly doing that. Of course, we would give priority to the law adaptation exercise first. But in the process of the exercise, if we notice that there are some parts of the legislation that are outdated, we will try to make use of this opportunity to propose amendment. There might be also some parts that are not suitable to the present situation of the Hong Kong SAR as its status. So we have come through the legislation and identified these problem areas. We will inform the relevant bureaus immediately, and they would handle the situation. That is, they would propose amendments to the relevant parts. Well, of course, during this round of exercise, we would do the law adaptation first as first priority, but at the same time, we would also make use of this opportunity to update the outdated part of the legislation and also propose amendments to the outdated parts. So there is not just this particular legislation. We have noticed that there are some other legislations that have the same problem. So we have drawn reference from the previous exercise, and we would try our best to rectify the situation. Well, of course, once again, the focus is on law adaptation first. I hope members would understand that we are trying our best.
We already talked about the policy matters in a macro perspective in the previous meeting. So let's carry on with the clause-by-clause scrutiny. Mr. Derek Lau, should we go back to part 21 on the reference table? Let's look at page 117 of the Chinese copy and 116 of the English copy. Now I'm looking at the reference table. We are at part 21, is that right? Yes. Please give us some time. For the Chinese marked up copy, it should be page 117, right? Correct. And it's page 116 of the English copy. We are now dealing with part 21 of the bill. Please give us some time. Page 116 for the English copy and page 117 for the Chinese copy. Please carry on. Clause 70 is to repeal Section 74(1) of the Legal Practitioners Ordinance, Cap 159. Section 74(1)(ca) lists out the identity of the members of the relevant committee. As mentioned, we are repealing the Solicitors, Trademarks and Patents Costs rules. And the director of the IPD will be listed as part of the cost committee. As we are repealing the Solicitors, Trademarks and Patents Cost rules, bracket 1, bracket CA should be repealed. Please move on. The next amendment concerns Part 50 of the bill. Please refer to page 234 of the Chinese copy. And there is only amendment concerning the Chinese version, page 234. For the English copy, well, there are no English amendments because we are only amending the Chinese version here. We notice that for Patents Ordinance and the Patents General Rules, there are some discrepancies in relation to the Chinese rendition. For the Chinese version, we are proposing to change the name of the ordinance. Instead of 專利權條例, we will have 專利條例, and there won't be any changes in the English version. Please move on. We'll now deal with clauses 140 to 142. Please refer to page 236 of the Chinese copy. And for English, it's page 245. Please move on. We are repealing Part 19. Sections 156 to 158 as well as Schedule 2. We are also amending Section 159. This took effect in June 1997, and this is in place of the old patent system. These are some transitional provisions. They are to deal with the transitional matters concerning the patent system. All these transitional provisions have expired, and so they have lost their effect. So we are proposing amendments to repeal these transitional provisions, sections 156 to 158, as well as Schedule 2. And for section 159, for the parts where there is mention about terms that appeared in sections 156 to 158, we are removing them. Please move on. Now we will deal with Part 50. Same as what we've just talked about. Please tell us the page number of the marked up copy first. Part 50. Page 245 of the Chinese copy. And page 254 of the English copy. Please proceed. Because of Part 68, Clause 234, bracket O, we are repealing the Solicitors, Trademarks and Patents Costs rules. That's why I think we should deal with Clause 234, bracket W first. Then we can better understand why we have to deal with Part 50. So you are now referring to the marked up copy concerning Part 68. You want to jump to that part, right? Yes. Page 467 of the Chinese text. That's page 3 of the reference table. Members, the administration is suggesting that we look at Part 68, that's page 3 of the reference table. Page 467 of the Chinese copy and page 462 of the English copy. This part is to repeal the transitional arrangement. Cap 514B. Before 1997, Cap 42 of the Patent Registration Ordinance was enacted, but now it is repealed. So under that ordinance, anyone that provides the relevant papers could have their patents protected. That was under the old patent system. Now, the existing system was enacted in 1997, and applicants will have to, through the new system, concerning their patents registered in the UK, they'll have to go through a re-registration procedure in Hong Kong in order to have their patents protected. For Cap 514B, it is about the transitional arrangement. That is, before the establishment of the old system in 1997, the patent was already registered in the UK, but then it is not granted in Hong Kong after 1997. That's why we had the transitional arrangement so that the patents could be protected in Hong Kong. The validity period last for 20 years, counting from the patent registration date in the UK. Now these patents have already expired, and there will no longer be any patents registered in the UK that could be protected in Hong Kong under the transitional arrangement. That's why Cap 514B that deals with the transitional arrangement will not be in use, so it can be repealed. Thank you, Madam Chair. Please carry on. Now let's go back to Part 50. Please hold on. I'd like to ask about page 467 of the Chinese copy. There are some consequential amendments. Do you need to go through them here? Well, we're repealing both the Chinese and English parts. Do you have to go through page 537 of the English copy? That's another part. That's a different part. Okay, let's follow your train of thoughts. Now let's go back to part 50. Clause 143 and 145. It's page 245 of the Chinese marked up copy. Page 245 of the Chinese copy. That's the Chinese version. For the English version, it's 254. Page 254. Yes, please move on. Part 50. Clause 143 and Clause 145, they relate to the same matter. It is to repeal Sections 105 to 112 as well as Schedule 3 to the Patents General Rules. Sections 105 to 150 as well as Schedule 3 empowers the Director to repeal Cap 154B as well as to deal with matters related to registrations as mentioned. There might be patents registered in the UK, and those information could be recorded in our register, and it empowers the Director to remove the information on the register as the old patent system is repealed. So sections 105 to 112 will lose their effect. Also, the patents registered under Cap 514B have already expired. So sections 105 to 112 as well as Schedule 3 to the Patents General Rules will be repealed. Now let's deal with Clause 144. Page 251 of the Chinese copy. And page 260 of the English copy. Yes, please carry on. This is Schedule 2 to the Patents General Rules. Schedule 2 lists out the fees that need to be charged under certain circumstances. For example, there is a patent registration and a notice fee will have to be paid. And if the patent has to be renewed, there is also a fee incurred. And Schedule 2 sets out the fees concerning Section 108. We have already suggested repealing 108. So we are also proposing to repeal Schedule 2, where references to Section 108 is mentioned. Now we come to Part 52. It is about the Registered Designs Ordinance. Please hold on. C2712 of the Blue Bill. Do you need to go through that part? The Schedule 3. Please refer to the page numbers of the Chinese and English marked up copies.
For Schedule 3, please refer to Chinese text page 252. Schedule 3, it's about repealing 105 to 113, because Schedule 3 is about the transitional arrangements. All right, please continue. Well, we understand that there are parts that are interrelated. However, since there are a lot of legislations that we have to go through, please try to stick to the markup version as much as possible. Yes, understand. Next, it's Part 52. Clause 153, 256 Chinese text. English text is, please wait. (265) for the English text. Blue Bill 176. It's about the Registered Design Ordinance. It was in effect in 97, setting down the registered designs, and it was under the protection of the Cap 44 of the law of the United Kingdom. (93)(4) states that for these sections, in any proceedings for infringement of a design to be registered under this ordinance, the court shall apply the law of the United Kingdom in relation to infringements. In other words, the court has to refer to the law of the United Kingdom regarding registered designs. So Section 93(4)(a) has to be repealed because the mention of the law of the United Kingdom appears here. So in order to accurately refer to the status of Hong Kong as the Hong Kong SAR of the PRC, we propose to cross out the line of the United Kingdom. We suggest to replace it with applicable in Hong Kong in relation to infringements occurring before the date of commencement of this ordinance, as if the United Kingdom Designs Protection Ordinance Cap 44 had not been repealed. So if Cap 44 has not been repealed, the protection area, the scope of protection, and the infringements arrangements will have to draw reference from the United Kingdom Designs Protection Ordinance, Cap 44. So this is a technical amendment, and there is no substantial change in the drafting content. Professor Leung, 4 minutes. Madam Chair, I'd like to go back to the point that I just raised. Just now, the administration mentioned that there is a time limit of the certain ordinance, and before the resumption of sovereignty of Hong Kong by the PRC, these were valid. However, there was an expiry date. Now that you want to retain the mention or the use or the arrangements of referring to the United Kingdom Designs Protection Ordinance, can you tell us the rationale behind this? Professor Leung, since we're going through it clause by clause, I think since we're doing the clause by clause examination, if your question is not in relation to the particular section of the ordinance, perhaps you could raise that questions afterwards, or either in writing or after the meeting. No, Madam Chair, this is related to the ordinance. I want to ask, why is it that they want to cross out the existing laws and then ask the meaning to be retained? I think this is in line with the questions that we are talking about now. So I have no objection to repealing the lines of the mention of United Kingdom legislation. Well, thank you. I understand Priscilla Leung's concern. Yes, indeed, this part of the legislation may be applied under certain circumstances. Though now we're talking about the situation before 1997, the valid date of the Registered Designs Ordinance could be extended, at most extended to 25 years. So for infringements lawsuit, could be the period would be 7 years. So some of the infringement cases may have to be extended to 2028, and this ordinance will still be valid by then. So we suggest to revise the legislation in this way, so that for cases that are still going on or that might be extended till 2028, this part of the legislation could still be in use. All right, please move on. Next, Part 53. Chinese version is page 257. 257 of the Chinese text. English text is 266. Part 53, section it's about copyright ordinance. Section 115, regarding presumptions relevant to literary, dramatic, musical, and artistic works. There are some presumptions here under 1155B. It states that the plaintiff's allegations as to what was the first publication of the work and as to the country of first publication are correct. That is, if the author is dead or the identity of the author cannot be ascertained by reasonable inquiry, it is presumed that in the absence of evidence to the contrary, the plaintiff's allegation as to what was the first publication of the work and as to the country of the first publication are correct. When you explain about the amendment, please also state the page number of the text of the on the markup copy. All right, 1161B to D and 3B, they are all about the mention of the term specified country. There are presumptions relevant, for instance, to literary, dramatic, musical, and artistic works, and also to sound recordings, films, and computer programs. 1155B, 1161B to D, and 3B, there the mention of the term country. So our policy content is to cover all places in the world, including the mainland China, Hong Kong and Macau as they are, as well as Taiwan. So in order to accurately reflect this policy content, we propose to amend this term. We suggest to replace the word country with country, territory, or area. In fact, ordinance in relation to copyright and intellectual property, we often refer country as country, territory, or area. All right, please move on. Next, Section 151 and 152. Chinese text is 261, starting from page 261. And you haven't covered 150, right? Section 150? We're now on Blue Bill 150, bracket 1 and 2. What page is that on the markup version? Chinese 261. English text 270. Please move on. This is regarding Schedule 2 to Copyright Ordinance. We propose to amend Section 34, bracket 1A. On Section 34, it states that Section 182 of the ordinance applies to an existing work if it was made before the commencement by or under the direction or control of Her Majesty in light of the government of Hong Kong. So the validity period is 125 years after the work was made. So making reference to the relevant ordinance, we believe that the mention of Her Majesty in light of should be crossed out. This is not a substantial amendment. It is just technical and it will not affect the policy content of the ordinance. Please move on. Blue Bill, Part 15, Section 153, Chinese text, page 260. Which part is that? Which part? Part 53, Madam Chair. English text 271, page 271. English markup copy. We propose to repeal Section 41 of Schedule 2. Which states that the rules are in force immediately before commencement, subject to such necessary adaptations and modifications as may be necessary. So with the new amended ordinance, Section 41 had been repealed. So we also suggest to repeal it here, Section 41 under Schedule 2. Please move on. All right, now we are on Part 68 regarding 2340 and 234W. We can now move on to 235, Section 235. Chinese text is on page 522. 522, Chinese text. English 537. English text 537. It's regarding specification of public officers' notice. The Director of Intellectual Property is the Register of Patents, that is under Cap 514B. So since the previous section had been repealed, so we propose to also cross out this mention of the Director of IP as the Registrar of Patents. Please continue. All right, I've covered the parts that we propose are relevant to our department. Okay.
Now we'll move on to another bureau. Secretary of the LLC, please let us know which government representative will walk us through the next part. Thank you, Madam Chair. Now the amendments concern the Environment and Ecology Bureau, Part 23 of the bill. It is the amendments concerning the prevention of cruelty to animals regulation. Will only amend the English version. Please refer to page 139 of the English text. There are no relevant amendments in the Chinese version. I'll invite Mr. Luke Chen from the Environment and Ecology Bureau to walk us through this part. Thank you. We are now dealing with Part 23. There are no amendments in the Chinese version. Please only look at page 139 of the English version. Please carry on. We suggest making amendments to Section 14 of Cap 169A. We suggest removing the word territorial here. This provision empowers law enforcement officers to board any boats or vessels within Hong Kong waters, and it is also about rules about cows being exported. This is a technical amendment, and there are no changes to our policies. Professor Leung. Back then, when you decided to include the word territorial, what was the consideration behind? This regulation was enacted back in 1935. This is an old provision, and the references made back then do not necessarily suit our status as an SAR of the PRC. That's why we are proposing this amendment. Well, I'd like to make my question more precise. That means the word territorial does not appear in other legislations now. Well, let me supplement. After the reunification, we no longer adopt this term when we draft any laws. As for any legislations still containing this term, we'll have to refer to Schedule 9 to Cap 1 of our laws. Schedule 9 of Cap 1 will no longer have to exist if we have made all the amendments to remove this term. Well, that means you'll have to remove this term from all the provisions of other legislations as soon as possible. Well, in the previous amendment, we made a similar removal. So we have completed Part 23. Now let's move on to the next part. Mr. Lee, Senior Counsel, please let us know which government representative is responsible for this. Is another amendment concerning the EEB is Part 40. The Electricity Supply Regulations, Cap 406A. I'll invite Mr. Derek Chow to walk us through this part of the bill. The speaker is off the mic. Am I getting through? Yes. Part 40, 41, and 42, we will look at them together. The reasons behind the amendment are the same, so I will give members a briefing, then I'll ask the EMSD to walk us through each part of the bill. We refer to the Electricity Supply Regulations, CAP 406A, the Electricity Wiring Regulations, CAP 406E, and the Electricity Product Safety Regulation, CAP 406G. We're amending these three regulations. And the reason for amendment is to have the safety standards published by the IEC replace the safety standards published by the BSI. The content of the standards are the same. That's why the changes to the three regulations will not affect the electricity safety standards of our electrical appliances in Hong Kong. I'll invite Mr. Leung to elaborate now. I am Mr. Leung Yu Hong from the EMSD. I will now brief members on the details. I will first talk about Part 40 concerning the Electricity Supply Regulations CAP 406A. Please tell us the page number of both the Chinese and English text. For the Chinese, marked up copy is page 176. And for the English text is page 184. We are at clauses 104 and 105 of the Blue Bill. This concerns section 4, minimum size of conductors. We are amending three major terms. For the first amendment, concerning the part about each of which is of number 22 standard wire gauge, we are amending it to the sectional area of each is 0.0006 square inch. And the second amendment, we are amending from that gauge to the relevant area. And the third part, we are amending the phrase that of single wire of number 16 standard wire gauge efficiently insulated to that of a single wire that has a sectional area of 0.0032 square inch and that is efficiently insulated. We are amending these three phrases because number 22 standard wire and number 16 standard wire gauge are in compliance with the UK standard, and this is a way to standardize the sizes of wire gauges. Clause 104 bracket 1 bracket 2 and bracket 3, we are adopting a new number in place of the British standard. And we are using square inch instead. Next part, please. Next part concerns clause 105 bracket 1. Please refer to page 177 of the Chinese text and to page 185 of the English copy. We are amending section 13, subsection 3. we are replacing the British Engineering Standards Association with the International Electrotechnical Commission. This is because the safety standards established by the British Engineering Standards Association applies to the UK, and we think that the standards published by the IEC are more widely recognized in the world. So we will have the IEC standards replacing the standards published by the BESA. Mr. Holden Chow. Thank you, Madam Chair. Just now you mentioned about number 22 and number 16 standard wire gauge, and you are using square inch as the unit instead. So you will use square inch as the measurement, and I understand that. Now we come to section 13 subsection 3. You are removing the term the British Engineering Standards Association. Instead, you have the International Electrotechnical Commission. I get this part. For standards recognized by the IEC, are they in conflict with the standards published by the British Association? Say, for example, for the measurement for the wire gauges, if you follow the IEC standards, it could be 0.007 square inch. I'm just giving a random example. Will you adopt the same specifications set out by the IEC? Any changes to the standards? The first question is about the safety standards set by the IEC. The standards made by the BESA as well as the IEC are consistent with each other. Secondly, on the specifications for wire gauges, can we adopt the standards established by the IEC? Well, we did a search. There are no equivalent standards in relation to the specifications of wire gauges. That's why we adopt a different number concerning the specification. And for the rest of the ordinance, we will try to adopt the standards set by the IEC as much as possible. Understood. Please carry on. Now, clause 105 bracket 2. That's page 177 of the Chinese text. And page 185 of the English text. Chinese copy, page 177. English copy, 185. Section 13, subsection 3. We are repealing the information about number 8 SWG concerning the conductor. Section 13, subsection 3, there is another table. Again, we are repealing the standards for the wire gauge. We adopt the British Standard wire gauge concerning number 8 SWG and number 10 SWG. As mentioned, this is about the sizes of wire gauges that apply to the UK. We are repealing the parts that cite the standard wire gauges in subsection 3. Please carry on. page 180 of the Chinese text and page 188 of the English text. The Chinese copy is 180, and for the English text is 188.
It's regarding section 13, bracket 11. We propose to replace British Engineering Standards Association and the Post Office (bracket London) with International Electrotechnical Commission or any equivalent body recognized by the Director of Electrical and Mechanical Services, because the previous one is applicable only to the UK and its colonies. We feel that IEC is more widely recognized. So in 105 bracket 4, we have already proposed to replace the British Engineering Standards Association with IEC. So for this part, we also suggest to replace the relevant part with IEC. Please proceed. All right, next is Chinese text, page 183. English text, page 191. Part 5. It's regarding section 13, bracket 17A. We propose to delete bracket A and replace it with the specifications for the time being in force of the IEC or any equivalent body recognized by the Director of Electrical and Mechanical Services for such an overhead line. Well, as mentioned before, the standards of British Standards Institution is applicable to the UK and its colonies only. So we propose here to replace bracket A with the relevant parts and specifications of IEC. All right, please move on. We've covered part 40 now. We're now moving on to part 41. It's regarding electricity wiring regulations, Cap 406, sub-legislation E. What is the page number, please? Sorry, Chinese text is page 185, and English copy is page 193. On the blue bill is 106 bracket 1 and 2. We propose to amend section 2 on interpretation. Regarding the definition of current carrying capacity, we propose to delete the lines, the regulations for electrical installations as published by the Institute of Electrical Engineers, London, England, and as those regulations may be, which should be replaced with the Code of Practice for the Electricity Wiring Regulations as published by the Director and as. And the second part of proposed amendment is at the end of the paragraph to replace in those regulations with in the code. It's because the regulations of the Institute of Electrical Engineering London is applicable to the UK and its colonies only, so we propose to delete this line and replace it with the Code of Practice for the Electricity Wiring Regulations of Hong Kong. As in 106 bracket 1 and 2, we have already suggested to replace the regulations of the UK standards with the Code of Practice for the electricity regulations in Hong Kong. So this is a consequential amendment. All right, we have covered part 41. Now we will move on to part 42. It's on electrical products safety regulation, Cap 406 G. There are quite a lot of proposed amendment here, but basically they are just straightforward and technical. We just want to replace the relevant UK standards with the IEC standards. Chinese text 186, Chinese text 186, English copy, page 194. Blue Bill 107 bracket 1. We propose to amend relevant parts of Section 2 on interpretation. First, we propose to repeal BS, the British standard, with, that is 1363 Part 2, with IEC 6884, because the previous is only applicable to the UK and its colonies, and the IEC is widely recognized in the world, so we propose to replace these relevant parts, mentioning BS 1363 with IEC 6884, IEC 60884. I have a question. Was some you propose to delete the relevant lines, whereas others you propose to replace the entire paragraph with a new one? Is there any changes to the present standards adopted by Hong Kong? No, there is no substantial change. And the prevailing standards will not be affected. All right. 107 bracket 2, Chinese version is 186 and English version is 194. Two bracket 1, about the definition of standard, we propose to delete bracket A and B. This is also because we will no longer adopt the UK standards or the European standard. So in section 107, subsection 2, we propose to delete the relevant parts. All right, please move on. On the same page, 2 bracket 1, we propose to delete BS, the definition of BS and EN, because the amended version will no longer adopt the BS, the British standard, or the ES, European standard. So in 107, subsection 3, we suggest to delete these two parts in relation to the mention of BS and EN. All right, please move on. Chinese text 189. 189 Chinese text, page 197 English version. Blue Bill 108 bracket 1. We propose to amend bracket 6, the mention of BS 546 or BS 1363 Part 1. We propose to replace it with IEC 683 or an equivalent standard and IEC 6884 or an equivalent standard. Same as what I've mentioned before, the BS and EN standards are applied in the UK and the European parts of Europe, so we suggest to replace them with IEC 683. On the same page, bracket 7, section 6, bracket 7, also to replace BS 3535 Part 1 and BS 4573 or EN 50075 with IEC 61558 or an equivalent standard. The rationale is the same as what I've mentioned earlier on. All right, please continue. 6 bracket 7. Delete BS 4573 or EN 575. Replace with IEC 61558 or an equivalent standard. This is also because the IEC standards are more widely recognized, so we propose to replace this, to replace the BS and EN standards with the IEC standard. All right, next, 190 for Chinese version and page 198 of the English copy. Blue Bill 109 bracket 1. Schedule 2, item 1, bracket A, bracket IA, that is to replace number of BS with standard. Since we are adopting the IEC standards, so we propose to use the term standard to replace the number of BS. 109, section 2, on the same page, schedule 2, 1, 3, bracket A, I, B, and C, to delete BS 1363 Part 1 with IEC 60083 or an equivalent standard and IEC 60884 or an equivalent standard. Rationale is the same as mentioned before. The IEC standard is more widely recognized in the world, so we propose to replace it with BS 1. So replace BS 1363 with IEC 683. Please move on. Chinese version, page 192. English copy is page 200. Blue Bill 109, bracket 3. This is Schedule 2, item 1, brackets 3. We suggest to cross out BS 1363 Part 1 or BS 5733 for plug which is manufactured to BS 5733. The construction and dimensions of plug pins, markings on the plug and fuse links shall conform to BS 1363 Part 3. To replace this with conform to IEC 683 or an equivalent standard and IEC 60884 or an equivalent standards. This is also because we propose to adopt the IEC standards, so we suggest to cross out the relevant part under bracket 3 and replace it with IEC, the relevant IEC and standards. On the same page, Schedule 2, 1, 3, bracket A, bracket 4, to delete the lines BS 1363 Part 1 and replace it with IEC 683 or an equivalent standards and IEC 60884 or an equivalent standard. Because we have adopted the IEC standards, so we suggest to replace BS 1363 with the IEC standards. Same page. Schedule 2, 1, 3, bracket A, 5. Delete BS 1362, replace it with IEC 60269 or an equivalent standard. Rationale is the same as mentioned above. On the same page, Schedule 2, 1, 3, bracket B, to delete the number of BS with the term standard. To delete the number of BS and replace it with the word standard. Because we have adopted the IEC standards, so we suggest to delete the number of BS and replace it with standard. Please move on. Chinese version, page 193. English version is page 201. Schedule 2, 1, 3, bracket B, bracket 3. Delete BS 546 or BS 5733 for a plug which is manufactured to BS 5733 up to the line BS 546 and replace it with IEC 683 or an equivalent standard and IEC 60884 or an equivalent standard. Please move on.
On the same page, Schedule 2, bracket III. We're replacing the removed part with IEC 60083 or an equivalent standard and IEC 60884 or an equivalent standard. We are adopting the IEC standard instead of the British standard. I say that in the following pages, similar amendments are proposed to be made and the explanation is the same or the explanation applies to the rest of the amendments. Say on page 193 there are 3 amendments. Can you just tell us how many amendments there are on one page, and you can tell us that the same explanation applies to all the amendments on the page, then you won't have to repeat them over and over again. Page 193 of the Chinese text and page 202 of the English copy. There's only one amendment left. Schedule 2, first item, column 3. We are replacing the BS standard with the IEC standard again. This is because we are adopting the IEC standard instead of the British Association standard. Page 194 of the Chinese text and page 202 of the English text. I'll talk about the amendments in one go. Schedule 2, first item, column 3. We are replacing we're repealing BS 546. Schedule 2, item 1, column 3, bracket II. We are repealing again BS 546 with IEC 60083 or an equivalent standard and IEC 60884 or an equivalent standard. Schedule 2, item 2, column 3, bracket IIB. We are repealing the BS standard with IEC 60083. Also down below, we are replacing BS 546 with IEC 60083. And column 3, bracket 1A, bracket II, bracket capital letter A, we're replacing BS 1362 with IEC 60083. And bracket capital letter B, we are replacing BS 646 or BS 1362 with IEC 60269 or an equivalent standard. That's all for this page. Again, we are adopting the IEC standard instead of the British Association standards. That's why we are proposing these amendments. Now we move on to page 195 of the Chinese text and page 203 of the English text. I'm going to talk about the amendments in one go. Schedule 2, item 2, column 3. We are replacing BS 1363 Part 3 with IEC 60083 or an equivalent standard and IEC 60884 or an equivalent standard. bracket C, bracket I, we are replacing BS 546 with IEC 60083 or an equivalent standard and IEC 60884 or an equivalent standard. Column 3, bracket C, bracket II, we are replacing BS 546 with IEC 60083 or an equivalent standard and IEC 60884 or an equivalent standard. Now bracket C, bracket II, bracket capital letter A, we are replacing BS 1362 with IEC 60269 or an equivalent standard. Last one on this page, bracket C, bracket II, bracket capital letter B, we are replacing BS 1363 Part 2 with IEC 60083 or an equivalent standard and IEC 60884 or an equivalent standard. That's all for this page. And the reasons for the amendments is because we're adopting the IEC standard instead of the British Association standard. Please move on. Page 196 of the Chinese text and page 204 of the English text. Schedule 2, Item 2, Column 3. Mr. Dennis Leung? Yes. I see that for the rest of the 3 pages or so, we will see the same proposed amendments. Perhaps the administration can tell us that there will be the same proposed amendments for the rest of the pages. Then the administration won't have to repeat the details. Perhaps you can further simplify your briefing. Please tell us how many amendments there are on each page, and then you can tell us that the previous explanation applies to these amendments. If you want to supplement, you may do so as well. Thank you, Madam Chair. Page 196 of the Chinese copy. There is only one amendment on page 196. Schedule 2, Item 2, Column 3, bracket capital letter C, we are replacing BS 646 and BS 1362 with IEC 60269 or an equivalent standard. This is because we're adopting the IEC standard instead of the British Association standard. Please carry on. Page 197 of the Chinese text and page 205 of the English text. There are 3 proposed amendments. We propose these amendments because we are adopting the IEC standard instead of the British Association standards. Now we move on to page 201 of the Chinese text and 209 of the English text. There is one proposed amendment. We propose this amendment because we are adopting the IEC standard instead of the British Association standard. Yes, please continue. Page 202 of the Chinese text and page 210 of the English version. There are 3 proposed amendments on this page. We propose these amendments because we are adopting the IEC standard instead of the British Association standard. We're coming to 10:40 a.m. After we've wrapped up this part, we will have a 10-minute break. Mr. Chow, please. Page 203 of the Chinese text and page 211 of the English text. There are 3 simple amendments. This is Clause 101. This is to repeal bracket A bracket III under Schedule 5. We are removing the outdated organization. We are going to have a 10-minute break and we will resume the meeting at 10:50 a.m. Thank you.